And Nita, did you have anything you wanted to focus on today, for those administrative claims?
I think particularly just moving on into the small claims and getting started with that. We have about 54 administrative claims that were rejected between February 17th and March 4th, and by the city of Oakland. And so we're just ready to start moving on to getting these into small claims for folks.
And those were all like City of Oakland property claims against the City of Oakland?
Yep. And we're still collecting, we're still moving on with new claimants, and just to continue to file claims with the administrative claims of the City of Oakland. But we're now, I think, we have like a 6-month period to take it to small claims. So we want to make sure that we get these in. And that's what I need help with. I don't have the capacity to do everything.
Right. And that's one thing we'll be hoping to do is, help Anita go out, meet with those claimants, and help them file those small claims, within the next few months, because the deadline's ticking now. Right? So hopefully this is the start of something beautiful. Plant seeds. I'll start recording.
Yeah, no, you go for it. Go for it.
I don't know, one thing I talked to Robbie about that I wanted to just
recording in progress
reiterate was we've had such a terrible time with not just securing attorneys or legal support, but once we find the legal support, it's like this pattern of them just totally bailing and leaving people hanging. So at some point I wanted to talk about what does it look like. I don't know, Robbie and I, we talked about having a contract between the claimants and the members of this group so that there's some form of accountability and assurance. Because I know with some of the folks, I'm like, hey, members of NLG are going to be stepping up to support. And what I heard back from people was like, oh, just like the last time, those lawyers said they were going to help us and then didn't. Or those people said they were going to help us and didn't. And that's a real, point of disappointment. So I just wanted to put that out there of, moving forward, how do we hold everyone accountable and make sure that there's assurances in place for the claimants for the support they're going to get through this process, and can that include looking like contracts?
It's a commitment to undertake the helping somebody with one of these. Can't leave them hanging. But also, a lot of us also understand that, like, we can't represent anybody. People have to prosecute their cases. There's a balance.
It wouldn't be representation, but more support through the process. And then my understanding too is with small claims, you can assign someone to represent for you, right? And it can't be a lawyer.
No one can speak on your behalf in small claims in the sense of, and can everyone hear me okay?
Mm-hmm.
And everything. To my knowledge, and I might need to look at this, you can't have formal legal representation, witnesses that are speaking, but I don't believe that you can have folks that are speaking on your behalf.
My understanding was that you can appoint someone to represent you that is not an attorney. Like you can have an advocate.
That might be true for arbitration though, but not for any actual court.
Got it. So I think part of this then is also to have some kind of like one-pager for the claimant so that they understand what their advocate or their person who's, you know, helping them out can and cannot do, and what they're going to have to do in this process.
Great. Okay. Well, we can broadly get started. I'd love to get a sense of who's in the room. I know there's some folks that are legal advocates, some students, everything. So maybe if the folks in the chat or on Zoom want to just put in the chat if you're able to kind of like name, pronouns, affiliation, what you're hoping to get out of training. And then we could also do that with the folks in the room very briefly. And then I can introduce myself and then go into the training. So whoever wants to start.
I could start. I'm Robbie. He's A, and thank you.
Laura Riley, she, her, and just wanting to learn a bit more details about the process.
I'm Lisa, she, her pronouns, and I'm also just kind of curious about small claims court because I don't think it's something that we really talk about a lot in the law school curriculum. But yeah, just curious.
I'm Cody. Excuse me, they, them. I do attend Right Pro Bono project, and sometimes we can help people to go to small claims court, but I'm not really sure what that entails. I'm curious what it's like.
My name's Julian. I use he, him pronouns. To all, started with the suitcase clinic. It's like a local unhoused, the link from EMS, legal referrals, whatnot. And yeah, somebody just anywhere in the
I'm Angie, she, they. I'm a 1L. And yeah, I'm just interested in learning more about the process in general because I don't know too much about it. Yeah.
Hi, I'm Irene. I use she, her pronouns. I also just want to learn a bit more about the small claims.
And all students. Right? Okay, cool. Great.
And we got people on the computer.
Yes, yeah, and I got we'll look at folks chat messages that we have to put today. Yeah, of course, if people have specific messages, please put very specific questions. Please put them in here. I won't be very good at like monitoring it, but I'll do my best. Me, some background on me. My name is Andrew. Here are the pronouns. I work at Lawyers Committee for Civil Rights of the San Francisco Bay Area. As a part of that job, I was involved on the Coalition on Homelessness versus the City of the San Francisco lawsuit that was initiated in 2022 and settled last year, which initially was about both the criminalization of homelessness and the destruction of unhoused people's property during sweeps in the city of San Francisco, but after grants passed ended up being reduced to just being about the things related to destruction of property. And it was a class action, and our settlement included some monitoring and enforcement, and basically the requirement that the city, follow its bag and tag order or changes its bag and tag order, and I'll explain what that is, to have a certain number of minimum standards. Now, as a part of that lawsuit, some of the plaintiffs and witnesses and other people we were working with in San Francisco, we basically went through this process with them. We went, and again, I'll explain all of this, but filed administrative claims with the city of San Francisco regarding the destruction of property, and then if those claims were denied, went through the small claims process with them. And I only came on to this case, in the last year or so of it really being actively litigated, and only really supported 4 or 5 admin claims and small claims cases. But have gotten a lot of information from other people and helped update with materials, and train some folks. But I'm definitely not the end all be all on certain pieces of it, especially some of the procedural nuances of small claims court. So I welcome the knowledge of folks that are in this room, and I'm happy to help to look into other questions kind of further down the line, especially as we are trying to develop a one-pager or anything else. And my work now is much less focused on the unhoused advocacy work, but I'm still doing a little bit of support with the kind of implementation, monitoring of the Coalition on Homelessness settlement. So I don't, yeah. And some of this, was originally related to San Francisco. I've tried to put some additional claim forms and other things specific to Oakland, but there are a few things I did not 100% get in terms of like how the proof of service works and the likelihood of success, those sorts of things. I don't necessarily have. And it sounds like folks are a little bit more interested in the small claims process, so I'll talk a little bit more about that. But this is kind of the overall process for everything, and let's get into it. So basically, administrative claims are required under the Tort Claims Act prior to commencing a small claims action against a city, a government entity. And in this context, that could be not only the city of Oakland, the city of San Francisco, but also things like Caltrans or BART or whoever owns the specific land that the property is taken from. And I have, examples of these forms that, and basically like intake guides. I don't know if any of the things I shared were like shared out with the group in advance, but I can share all of those later on. And there's also like a packet of Coalition on Homelessness created and some of the information that's needed for it. But the admin claim questionnaire is relatively straightforward. Has like what happened, give like a narrative of the situation, provide a list of the items that were taken, and to the best that you can, evidence of takings and the cost of each of those things. We'll go into like a little further down the line how best to get that information and how to make sure that these can be successful. But I think for right now, I'll just say it has some of that basic information that's in there. And again, every government entity has different claim forms, but they all generally have the same information in them. And the timelines here are like some of the most important things. Folks have 6 months from the day of the injury to file this property loss or personal injury claim against the city. And it is possible to file for leave, present a late claim, and those are often but not always granted. And here are the bases on which you can potentially have a late claim. And we really want to try to get everything that we can within those 6 months. Both because of not having to go through the late claims process, but also just spoilation of information. Like not being able to stay in touch with these folks, things like that. So the city or any government entity will have 45 days to approve, deny, or request more information. And if they don't receive a decision, the claim is assumed to be denied. Virtually every admin claim that we filed was denied within the 45 days. Sometimes we didn't get a notice, and often that was because of address issues were sent to people at their addresses that they weren't able to have access to after that time. And it sounds like, Nita, that has also been the case in Oakland as well. That the vast majority, if not all, of these admin claims have been denied. Is that right?
Yes, they have all been denied, and it's so interesting because they're like blatantly. The city was just blatantly in violation of their own policy as well as a court order.
Yeah, exactly. So this is almost exclusively like just an administrative hurdle that folks need to go through before going through the small claims process. I've heard of like 1 or 2 situations where the city has like settled before the process of like the claim being denied or something, but I haven't heard of any, at least in San Francisco or Oakland, where it's actually been, approved in this period of time. So after the claim is denied or has been assumed to be denied, the claimant, the person who was injured, has 180 days from the date of denial letter to file file in small claims court, and if they didn't respond in the 45-day period, the claimant has 2 years to take legal action. Again, there are some situations where we aren't sure if they actually provided the letter or not. The address may have changed, it may have gotten lost in the mail. They may have said that they sent it out, but didn't actually send it out. So we try to do, 180 days, plan for 180 days from even the date of the permanent claim being submitted, because we have no idea when within the 45 days they might actually bring it back. So it's definitely something that can be fought over and has been successfully if there's no proof that it was actually received. But I think the best thing to do is to try to keep it within 180 days. Also, just for the purpose of keeping the momentum, building and continuing to kind of have rapport with the person you're working with, all of the rest. And again, we're just going through kind of the administrative process, and I'll talk more about what's actually in the claim soon. Okay. Small claims, some general things about small claims court. Again, it's pro se. You cannot have an attorney that is representing and speaking on your behalf at small claims court. The plaintiff cannot appeal, but the defendant can appeal, and that is something that they have often done and have unfortunately succeeded on several of the times. I should double check this, but I'm pretty certain the maximum recovery is still $12,500, at least as of 2 months ago in San Francisco. That was the case. The judge hears the case without a jury, and can make its own decisions, right on the spot, or can issue a written order later on. There can be witnesses, and there are often witnesses. Usually there's, in San Francisco, it would often be someone from the Department of Public Works, a representative there, and the claims adjuster, insurance person that are speaking. And, on our side, we try to have other folks that were actually present at the taking, at the sweep, that are able to speak on the person's behalf, or not on the person's behalf, but in support of the person's claim. That is often difficult. Rules are less formal, but this is, I think, one of the biggest parts that these judges kind of really do whatever they want. They can interrupt folks. They can be very disrespectful. They can clearly take sides. They can do a lot of things to make just the folks that are going through this process feel extremely invalidated. And there's relatively little that can be done. There's some instances in which you can file a motion later. It's a challenging time, I think, for some folks. But it also means that you don't need to go through exactly as many of the administrative hurdles to bring in evidence or have witnesses or other things. There's certainly here's things that sometimes gets through. But often the informality is supporting the police and all of the rest of them, unfortunately. Did someone have something to say? Sorry. No? Okay.
And I did want to go for it. You talked about it pro se. I did see that the form SC-109 has authorization to appear on behalf of the plaintiff.
Yes. Okay. Yes.
So you can at the hearing you can have assistance with permission by the court.
Yes. Yeah. That's true. What I mentioned. Okay. No one else said anything there. I'm sorry. These things are all basics. Oh, yeah.
I truly have no idea how map works.
Are we Acrobat or PowerPoint? Oh, great.
Yeah.
Okay. Great. So, the plaintiff must file a copy of the SC-100. So none of these forms or anything were sent out to anyone in advance, and no one's seen them. I can after this, I don't know, plug in my computer and show you a few of them.
Pass around a little flyer, I think.
Or I can send them out later on. But basically, this is the process for filing. The SC-100 is just a basic a basic form, like somewhat similar to the admin claim form, but can include attachments. And we have a kind of template that includes like a lot of legal precedent based on, that provides that folks have the right to not have their possessions destroyed during these sweeps, where folks can kind of put in any additional information. And much of it is pretty similar to the to what's in the admin claims, but hopefully, some developed a little bit more. You can, submit Public Records Act requests to the police or Department of Public Works or whomever else to try to get, records of the sweep, etc. Just whatever you can do to build the evidence. But the thing that is most frequently done is the Public Records Act requests. And, there's some things here about the actual procedural process for filing.
Do you ever put like case law into your brief?
Yeah, so so the example brief has case law in it, and I think sometimes we've put like additional case law beyond what was in there. And I've kind of been a sweep for new cases in the past like couple years that have been favorable to us. Unfortunately, they're not very many. But I'm trying to think of situations where that's come up. Sometimes folks are and these claims don't necessarily need to only include like destruction of property. Sometimes they're also including like things related to injuries that folks receive from the police or emotional damage, other things. So I think that there are some situations in which folks have put in case law, say related to economic damages, like building that up a little bit more, like if there are particular there were sentimental objects, like trying to build case law to show potentially how much those cost. And again, there's some information in here already, such that we don't necessarily expect anyone that's filing needs to like add in new case law. But you can always, build in and expand on this, either specifically for individual plaintiffs or to like expand on this brief generally. I think that folks should always plan to use this, as a basic thing, but to expand on it. Is that
yeah. And we're going to have these sample briefs too. We can look over.
Yeah. Okay. Filing the service of process proof of service. I actually don't know specifically in the city of Oakland who you need to serve and whether it's accepted by mail. Maybe someone else in this room knows. But I can look into that, or other folks can look into it. And I now can't see any folks. If you have something to say, just say it. Okay, so that is procedural elements. Oh yes, someone had something to say. Okay. So this kind of goes a little bit more into like what to expect, a little bit less of the procedure and more about what these hearings actually look like. So well, number one, if you're, especially if you're doing a PRA related to these people, and kind of it's very basic. Like,
and the PRA is a public
records act request, or like sometimes called a sunshine request, like a next request. There's like all types of things. But it's as basic as like provide all documents related to Mr. the property seizure of Mr. Doe on March 1st at 123 Main Street, whatever. And they're obligated to provide things related to that, and especially if you can say in the PRA that it's like related to specific litigation. So they're supposed to provide all of those things to you in advance. You're supposed to have access to those documents. But like when it comes to the brief and the evidence that you're providing, and also like the brief and some of the evidence and the witnesses that they're going to have, that like, and correct me if I'm wrong, does not necessarily need to be provided in advance. Like you show up like 15 minutes before the hearing, and it's only then, like who is going to be, testifying, who are the witnesses, what brief do they have that they're showing to the government or to the judge, and like get a sense of their theory of the case. And the same on their side. You show up with like several copies of your brief and your evidence, and you just like hand it over like here, and then it's all kind of done on the spot. And anything you want to like object to or have problems with, you're kind of doing on the spot. And I've had situations where the government should have provided like particular police statements, or reports or anything else, and didn't, pursuant to their like Public Records Act request. And then like on the spot while I'm there, the plaintiff is like asking for a continuance to like look over the documents that weren't provided in advance. And you can also, I don't think this is on here, but you can ask for continuances on these hearings for like various reasons, which is especially relevant if you get in contact with the person, something like that. But so you say, okay, yeah. So you're exchanging this evidence like relatively quickly in advance, and that could include medical records, photos, videos, witnesses, witness declarations, receipts. You can getting copies of all of that and making sure it's all accessible and getting it organized can be difficult. So just
and are you are you filing this with the court beforehand, or are you just showing up with those documents?
You're filing the SC-100 in beforehand, which is like the claim, the like claim form, which you can include attachments to, but you're not obligated to provide the full brief until like 15 minutes before the trial, and the judge will not look at anything until the trial. Yeah.
Wow.
We have a couple more questions in chat, if you wouldn't mind looking.
Sure. Is my okay? No, this is just like a few minutes ago. Admin claims are different per city. So small claims forms are the same. There's like a California small claims form. Again, the SC-100. There are local rules that are like different from court to court. So like the Alameda County Superior Court has slightly different local rules than the San Francisco one. You're very long. I didn't notice anything that was like hugely substantively different. But if there is, it's probably just about like the font size or something. There's always something that's like tiny that's different that they complain about when you don't do. But the forms themselves are the same. Was that the only question so far? And thank you everyone for putting anything in your introduction.
That the shared screen is also black.
Okay.
I don't know if we're meant to be seeing anything, but
is it black now?
Yes.
Yeah.
Okay. I'm gonna stop share. Yes. Yeah.
For all these forms that require an address, for unhoused people, what do you put?
Yes. So we typically were putting our office, LCCRSF's office, but we have like a manned, like someone that is there that's looking over it. They also could be. I feel like that's typically what's done is they're sent to some sort of nonprofit or supporter. But good question, and that is like an important thing to figure out how exactly to maintain contact and everything like that. Okay, can folks see this now? It is somewhat similar to a trial in the sense that like you'll have kind of your opening statements where you're laying out the your theory of the case and then going witnesses one by one, and you'll have like a closing statement. But it's again very informal, and it's very likely that the judge will interrupt and kind of ask their own questions. A lot of time, like whatever you're saying is very in line with what is in the brief that you're filing, but you're not like necessarily expecting the plaintiff, the pro se plaintiff, to like be citing case law or anything. It's just like the case law. You can read the brief, but like this is unconstitutional under the Fourth Amendment. And here's why. Here's what they did. Here's what they took, et cetera, et cetera. Having as much the evidence and dates and everything here as clear as possible. I think that there's understandably, a tendency of folks to want to like editorial, is what I'll say, and provide their like interpretations of things that may not like be 100% supported by what the evidence is. Like, oh, they stole my stuff. They had it out for me because of X, Y, Z reasons. Which very much may be true, but just like focusing as much as possible on like the evidence and the facts and the dates and things that folks know, and like having those down as much as possible. And also just preparing it, like, I think the biggest part of this is just like preparing for like a very emotionally exhausting and challenging experience. I think we talk about, what is it, like procedural justice, giving people their like opportunities to like be heard and like have the court in the world like hear what you've been through and like in a fairly adjudicate it. That is often not what's happening in this situation. You're being interrupted. You're being like talked over by the police. They're offering these things that are not based on evidence at all, and it seems like the government, the judge may be going along with that. It's a very difficult experience, and I think just like preparing folks for like the sorts of questions that might come along that are very not respectful and like kind of ignorant based on the actual lived experience folks have is I think the biggest piece of it. Yeah, and then some reminders on court. I mentioned the thing about requiring or like asking for a continuance if you didn't get particular information. Okay, yeah, security is like an important piece of it. Exchange of evidence, presentation to judge, presenting your case. You're presenting your case first, and then remind you to witnesses and everything there. Yeah, judge can give the decision on the day of the hearing or issue the decision at a later date. I found often they're like, strongly indicating the direction that they'll go at the hearing, and then they give their decision in a written form later on. And may sometimes ask for like supplementary briefing or like further information, but I feel like doesn't. And in these sorts of cases, often it feels like it's very one-sided, and it's difficult for but sometimes certainly they can ask for additional information. And then again, like even if you win, then there's an opportunity for the opposing party to get to appeal within 30 days, and then then there can be like an appeals briefing. Something can be scheduled out a very long time. That can be like several months further down the line. And even if you do win and they don't appeal, you can seek to recover, and that can take many, many months because these governments move so extremely slow. Like we had a case that, oh my gosh, yeah, March of last year, we like won a trial, and I think the people just got the money like a month ago. So that's like 9-10 months. And hopefully it's not that big of an issue, but often it can be. So I think that the thing is, this can be a very, very long process. You have the events that occur can be 180 days, 6 months, more than that. Right? Someone else could do that. 6 months, and then then it can be 45 days, 6 more months, like 30 days of waiting, like months and months for the appeal process, and then potentially recovering. It can take multiple years, and it is often, I think the biggest part of this is just like maintaining contact and rapport with the people that you're working with. This going through this, many times can be like really intensely re-traumatizing, and even folks that feel like I've had a lot of situations where like folks call me like the day something has happened, like just really angry and adamant, like I want to fight this, I want to be involved, I like really I'm not okay with that again, and then months later they're like I don't want to do this anymore, like I'm just done with it, and that's very understandable, and that's happened to me in my life when I've wanted to fight authorities. So I think just like being honest with people about like what to expect, and more than that, their like likelihood of success, which I think we'll go into in just a moment, but just what the legal process looks like, and this is a lot less demanding, perhaps, than like the traditional civil legal process, but it still can be very challenging, especially the sort of timeline for it. So okay, yeah, here's what else I have. So yeah, these are some of like the specific forms. I might just do this on my computer to show a few of the other ones, but everything is in here, and I'll send it. And the templates, the destruction guide, the admin claim intake form, I think are going to be the most relevant ones. I think a lot of the procedural pieces can kind of be talked about separately. And this is wrong. So let's talk about kind of like likelihood of success and what my personal experience and maybe Nita and others' personal experience has been in kind of going through this process. Again, every single admin claim that we filed has been unsuccessful. Not unsuccessful, but like denied in the sense that it then moves on to the small claims process. And basically what seems to have happened is, I joined in 2023 at LCCR, and basically in the process where they were initially like investigating and had like initially filed the Coalition on Homelessness lawsuit from like 2021 until like late 2022, there was a lot of success with these claims. In the sense that the insurance adjuster, the claims adjuster, was very willing to settle after there was like a small claims after the brief and everything was filed, if it wasn't like crazy spurious. And then
In the brief, when did you file that brief into the context of the trial?
So maybe correct me on this, but I believe that you can file kind of like as an attachment to the like SC100 when you're initially like filing for the claim. You can also include the brief with that.
Okay,
but that's what we've been doing. But then like you can update it, and then because it's not actually the court that's going to be looking at the initial one, like they'll basically only be looking at the evidence that's in front of them.
So
but it's
claims.
Yeah, but it's something you can share with the claims adjuster and whomever. But correct me anyone on that. So then have a conversation with the claims adjuster. This is often attorneys that are having this information, negotiate, etc. And then they were able often to reach a deal and get to a number and provide that person the money, and often provide it on a pretty like faster basis than often would be the case for the traditional process. But basically, when I joined, that seemed to change. Yeah, go ahead.
Just to clarify, the claims adjuster, is that someone that works in like the city, or?
This was someone that worked for San Francisco. Okay. Yeah, that was like the one of the insurance people that was responsible both for the Department of Public Works and the police, and just like we like had her phone number, and we're like calling her anytime we filed these things to try to like confirm and settle any of these cases. Basically, when I joined and when there became and when Grants Pass came down and Governor Newsom just put forward both rhetoric and policy that was very anti-homeless, it seemed like someone in San Francisco got the message like don't settle any of these claims anymore. And so we were unable to settle any of the claims basically after that. And they seem to be fighting a lot harder on the small claims and bringing a lot more, firepower and witnesses and other things to the actual trials. And effectively have had no success in any of the small claims since then. I know of like 2 or 3 that were initially successful and went to the appeals process and then were shot down on appeals. And they will question everything, every piece of it. And because it's often difficult for folks to provide like clear evidence of like, how can you prove that the building was not soiled? Like I should have gone into this, but the bag and tag policy, at least in San Francisco, includes information that they are obligated to store and to provide a property receipt, bag and tag. Any items that are not like contraband, hazardous, soiled, things like that. And so often they will come and take things and write in their report like, oh, this was soiled and that's why we threw it out, etc., or destroyed it or whatever. And it's often difficult to like provide evidence that like contravenes that, and because the judge and other things are often just going with the story that the police or Department of Public Works are saying, it's often very, very difficult to just get them to believe folks. And so we've been telling people, the Coalition on Homelessness, which is now working to find violations of the San Francisco settlement, is also working with people to file small admin claims and small claims lawsuits, and they're doing like a lot of outreach and giving out a lot of know your rights information in advance. They're trying as much as they can to like have people keep journals, have people take photos of their possessions, have people if they can like keep receipts, because just every piece, like every factual piece of folks' briefs and claims will be just like torn apart, and just the police will have like will write something extremely generic that they write in like every one of their reports or something, or DPW will do so, the Department of Public Works, and just the city will go with that story. So I think that is kind of what has happened a lot more frequently recently. So this is obviously very challenging to know how to support folks that want to go through this process, who want to have their day in court, especially when they don't have like really strong corroborating evidence of their claims and of the specific items that were taken and the condition of those items, and where those items were, like whether they were blocking the sidewalk, like all these other things, like whether they complied, whether they took 5 minutes to pack up their things or 35 minutes, as that can change the calculus of whether they're taking the items. Whether it was intermingled, whether there was like one syringe that was in their like entire tent, and that like intermingling meant that like that they had to throw the whole thing out. Like all these like small, minute factual pieces like become the linchpins of the cases, and just like one small thing can like lead the judge to like totally throw out the whole case.
So when you're going to trial, you're bringing a set of witnesses to corroborate. You're bringing a brief, and do you have any declarations of that brief?
Yeah, so the cases that I've been involved in and that my immediate colleagues have been involved in have not had witnesses. It's very difficult to have unhoused live witnesses that are willing to take a whole day and go through this whole process, and leave their things behind often in order to do so. But we've had declarations from other unhoused witnesses. We've had declarations from attorneys that have witnessed sweeps, or social workers that have witnessed sweeps, or any number of other people. But those are filed, yes. Those can be filed initially with SC 100 or brought live to the trial itself.
Okay.
Yeah. So
you have brief and declarations, just written statements under penalty of perjury.
Yeah.
And whatever evidence, pictures and stuff like that.
Pictures, receipts, any like if you have the police records or the DPW records or anything from the Public Records Act requests that you file, you can bring those in. Just anything. I mean, some people have medical records if they're also claiming anything was damaged, that they're bodily damage or anything like that. And emotional distress. Sometimes people have like records of therapists or anything else like that. But yeah, there's a pretty there's a range of evidence that you could bring. I feel like there are some other neat things here.
What do you usually do for like emotional distress or like you have economic damages? Like how do you calculate that?
Yeah, there's like I forget what it is. Not more than double the actual like damages. The actual monetary damages. There's some case law in the brief, that basically says that California courts regularly award emotional damages for intentional destruction of property. Those don't like have very specific numbers associated with them, but there's like a bunch of, tort case law on emotional damages that you can also put in there if you're trying to like nail down a specific number. But a lot of what we were doing in the past, was starting high and negotiating down. But now that they're basically all going to trial, I think that they're starting with a more smaller number might be like strategically better, because like the judge will look at that number immediately and make their own judgments and like judge credibility perhaps on that, and then maybe question the other the value of the other items based on the value of the emotional distress.
We've got a few more questions in chat too.
Yes. Okay. I'll send the copies. Okay. I think it's like a magistrate judge usually. And I'm not sure if those, I think the ones that I've seen have been magistrate judges. I don't actually know what the process would be to like try to get a judge to like recuse himself or ask for a different sort of judge. But the ones that I've worked with so far have been magistrate judges. Yeah, this is, the gumming up of the works is really what this initially was supposed to be about, like when we had kind of a lot of them in like 21, 2022 that were filed, and it really like forced them in some ways to like change their practices and just like behave a little bit better. But I think that because this is in San Francisco, it could be very different in Oakland. Because these are now very on their radar, and they have like a script and a process of what to do, both initially to avoid liability and then in the actual trial to like defend their case. It's hard for me to say whether, if we start filing like 100 of these, whether it will like make a big difference in terms of how they're actually carrying out these practices. I think that could be very different in different cities, and I think it could be very different if all of them had corresponding evidence of every factual piece that their folks are often dinged on, which is to say the condition of property, the location of property, a corroborating witness, and like receipts of every piece of property. But those things are all very, very hard for people to provide in every one of these cases. So yeah, even if folks affected may be hesitant to stick it out all the way, I think that really depends on your like relationship with the clients. I was hesitant to push too hard on folks, just after seeing how going through the small claims process and like being in trial affected them emotionally. Like I was rarely pushing people. I wanted to support them in whatever they wanted, but be honest and realistic. And I think we've had, again, perhaps the majority of the situations are ones where we filed the admin claims and then haven't ultimately filed small claims, the small claims form, either because we lost contact with folks, they decided that they didn't want to go through with it, or like any number of other reasons. The attorney that was doing it, was no longer available, and they couldn't find like another attorney that would support, which I know we can talk about a little bit. What if it's prescription medication? So, these are like confidential. Well, no, I won't say that. I won't say that they're confidential. I think that I could be wrong about this. I think that the briefs can be filed under seal, or have certain components of them that are marked as confidential. Many of the small claims matters are public, and you can go into the court and walk in on a small claims matter. I highly recommend you do. It's very shocking and entertaining sometimes. But I think you can keep it vague, but also I think it is possible to keep them confidential in some ways.
Also, everybody on the chat, if you guys want those materials and quick put your emails in the chat, and so we can send that all.
Sure. Subpoenas. We have not done subpoenas. I think that we've just done Public Records Act requests because, again, they're obligated to provide this under Public Records Act requests, and I actually don't know what the subpoena process would be specifically in this, but we typically have just done Public Records Act requests. I don't actually know if you're guaranteed, like, the level of discovery that you're guaranteed in small claims, whether the obligations on the other side are exactly the same. But I could look into that. Citizen complaints, yeah, folks have definitely done that, and showed up to like public hearings, and people do all sorts of advocacy around these things separate from the admin claim and small claims process. But the admin claim small claims process is the only way, unless you're doing a civil lawsuit, to like get money back. And that's typically the reason why people are going through with it.
Also, one thing about the Public Records Act, for those who don't know, it's really easy. Any government entity, you can just email them, say, under the California Public Records Act, I want X, Y, Z document. You do that. They generally produce.
They generally do it, yeah. I had this whole project where I was trying to like get like records and videos and all these other things related to like police, suppression of protests from like 50 different agencies, like thousands of documents, etc. And I was surprised how many of them actually did it. But especially for basic things like this, and they have a process for it. Oakland is one of the worst that I have that I've tried to PRA in terms of like how long it takes and how responsive they are. And I've just gone into their office and like, know this woman that's there now. But they will generally produce it eventually. So, okay. Yeah, I think that you can certainly say that the city threw away receipts or threw away. What is often happening is they're throwing away people's phones where they have photos or records or anything else, or throw away people's journals. And that is like 100% an argument that can be made, but I think it's just been not the most successful. And it's why, witness declarations or live witnesses can be really helpful. So Nita, that sounds like Oakland. It's actually you can sue people for like not responding to Public Records Act requests. It's like kind of fun. It's like you can they're often successful and like give you attorney's fees. So I know people whose entire job is just like litigating Public Records Act requests that cities don't respond to, and actually like does get them to change their policies. It's like that's a great like fellowship project if you're looking for something to do.
And you have a fee waiver, you can sue them for the Public Records Act for free.
Yeah. Free money. But yeah, Oakland is pretty bad. Go ahead.
Can you say that one more time? What was the process to sue?
There's like I think it's like a typical kind of civil lawsuit. It's just under the Public Records Act request. But there's a lot of like very, very established case law on the obligations, especially if they're wholesaling, not providing anything. I think that there's things like investigatory records exceptions, or like what is too burdensome for them to provide, whatever. But there are like some times where like Oakland or whoever else is like totally ignoring the requests or giving you the runaround or like giving you totally irrelevant information, and that's like for things that other cities gave us in a day, and those sorts of situations are possible.
And I put your email in there. I can send you an example of a Public Records Act lawsuit. And I've done a few, and I just followed what some other attorneys have done in the past. Kind of worked.
Yeah. Okay. Yeah. There's no Know Your Rights flyer on filing small claims, but we have multiple of these like docket, some of whom are directed towards attorneys and some are directed towards individuals. I will say that I think our initial goal was to like develop knowledge in folks such that they could really truly file these and do everything 100% themselves. And that was just not like feasible from like, you know, having folks not having a consistent mailing address, being most simple to like the like getting all of the documents together, even printing, like it just ended up being a lot that had to go on whoever was supporting these. And I think that like often pro bono attorneys are taking these on without like an understanding of the obligations and like how long these things take and the amount of like very basic labor that needs to be done. Like someone needed to get like a pet sitter so they could show up to the trial, or like have someone that like Ubers to get there, and like have someone look over their stuff. Like there's just so many small things, like working with Unhoused people that you wouldn't think about that just make it really, really challenging to be a part of the legal process. And I think it takes a lot of like care and time and labor to support those things. And there are just a lot of attorneys who like want to sign up for something small and don't understand that. Yeah, okay, I'm just looking for the big things. Yeah, this is Nita. This is in Oakland. I'm guessing the like pink slips that are like when folks are supposed to.
Yeah.
Yeah. Agreed. Like we're you know in San Francisco that's a consistent issue where they're like putting one like notice of a sweet house in like a 10-block radius on like the back of a light pole that no one can see. So that's kind of like a separate thing. The question of notice for destruction of property. This is more just like they're destroying it rather than like maintaining it and making sure people can get it back. But the issues of notice, how long people have to get things, and the disability accommodations, like all of those are like other bases of lawsuits that I know folks are like still filing. But there are obviously challenges and a lot of time that goes into like bigger civil lawsuits to like try to change policy, and I think that a lot of those have been a lot less successful in recent years from what I've heard. And
although we just had a big success in Berkeley.
Did you?
Yeah, Berkeley Law case. The judge ordered they can't take people's motorhomes.
That's great.
Got a requirement that people be allowed to have tents in the city of Berkeley. At least for the people covered by the injunction.
That's great.
So there's still some things happening.
That's amazing. Yeah. Amazing. Other questions?
And, well, I know we have 5 minutes left, and so I wanted to, like, following up.
Sure.
So, like, you guys have the way we can follow up to ask clarifying questions.
Totally.
That'd be great.
Yeah. I will send all of these forms and documents with some explanations of them. I'm trying to think of other things I can do. I will not have the capacity to, like individually write briefs or look over briefs or those sorts of things. But I can provide some like technical assistance and like do this training to other people, or do this training in like a more detailed way on particular things, talking about my experience. But I honestly think that, Nita and others probably have like a good deal more of the like lived experience, especially of I think the most important things here beyond the procedural issues are just like how to like build client relationships and just support people in this process, and then just like how to deal with the like potential factual things that will come up in trial, and just building as strong of a factual record as possible, and depending on that factual record, like determining what might be the best course of action for like an individual unhoused person. And then just doing the like project management of this is happening over years, and like maintaining contact, all the rest. Yeah, but I can help with basics.
Right.
Yes.
I don't recognize there's like people from Santa Rosa,
Yeah.
San Jose, the Fremont. So I know there's a lot of mutual aid groups that are in Miami. But here, we'll maybe we should close it out and you know.
I have a couple of questions. Do I have time to ask them?
Oh yeah.
First question was, during trial, can other claimants or supporters attend the trial? We were talking with some of the claimants saying that it would be like we wanted to do like role playing before they go to trial, and that to show a sense of solidarity, but also so folks could kind of get a sense of what to expect. We wanted to see if people could actually attend each other's trials.
Yes. I am almost certain of that. I, as an attorney that was not, formally connected to the case at all, could sit in the background, and there's chairs in the back, and, other people come in. So I don't see any reason why not.
Okay. And then my second question was, how do people file a small claim against a service provider, particularly like a shelter provider? We just have a terrible situation in Oakland where every single service provider is involved with fraud and abuse and exploitation and trafficking at the in the shelters. And so folks are, and one particular shelter that I'm working with the residents at, they want to sue the shelter provider. And so I'm wondering, how do we do that in small claims?
Yeah, is this a city-run shelter or like a privately run?
It's a city-owned facility with the shelter is run by a nonprofit.
I would need to think about that and double check it. I think that it could be complicated whether you're suing the nonprofit as as a business, or it would be against the city. But it is possible to sue businesses. It's just not, you wouldn't go through the administrative claim form process initially. I think that you can do that kind of.
You would go straight to small claims?
If it's, totally like separate from the government, then yeah, the admin claims are sort of the administrative process under the California Tort Claims Act, kind of in order to sue a public agency. But to my knowledge, it is not required to do that for like a business or like non-governmental agency.
Okay. So that would be like that thing where the city owns the facility and contracted the service provider, and then the service provider has fully broken the contract. That's kind of, we might have to go through the administrative claim process first and then the small claims?
Yes, it would depend on like how intermixed the like city is with the like third party agency, whether it would be considered like a city run thing where you're suing the city or you're suing the like nonprofit itself. But like the constitutional obligations of a like nonprofit are very different than the constitutional ramifications of the government. Like the government can't take your stuff, but like if a person takes your stuff, that's
different.
I think that like while there may be some things that you could sue a like external third party agency for, I think that it would be very different and a lot more limited than the process for suing the city.
Okay.
Any other questions?
No, not for me.
Okay, great. I put my email here. I have some of these emails that folks that maybe you can send.
Yeah, let's copy paste them.
And thank you. If you want to, learn more about my org, the things we're doing, just like other homeless advocacy work, generally that's going on in San Francisco or otherwise, please let me know. I might not be doing it myself, but can like connect you with other people. And I this is like a really important area of work and an area where you can get a lot of like legal experience very quickly. It can be very, very challenging, both legally and emotionally, but it's been like super, super rewarding for me. And I really value all these folks' time and my interest in getting involved in it. And yeah, hope you keep fighting the fight. And it's really heartening to hear about the success in the Berkeley case, and I hope that there can be more fights on these sorts of things. Sure.
Thank you so much.
Yeah.
Okay, all right. That's that.
Recording stopped.
Thank you all for coming, and I apologize for the technical difficulties.
They're all my fault.
Oh, okay. Well, thank you. Thank you for taking the point.
Thank you so much for all this.
Yeah, thank you.
And hopefully get some more going. And Nita, you got this coming Monday, right?
This coming Monday, that would be if people wanted to help folks file the administrative claims. But on Tuesday, we can visit the sites where people have already filed the claims and have been denied. And on Thursday nights, I go to a site where a majority of the folks have filed claims that have been denied. So, yeah.
Okay. Well,
so Monday, Tuesdays, and Thursdays. I'll send you the dates and times and whatnot.
Well, we got some good education now. Thank you so much, man.
Yeah.
I appreciate it.
Yeah.